I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am bringing you number 96 on our compilation list. Yes, this is number 96 that we are jumping into on today. And today, we will be in 5 different judges' courtrooms for some classic moments, some head scratching moments, possibly for some of you, some funny moments. But nonetheless, we'll be in 5 different judges' courtrooms. Before I give you the rundown on those judges, just want to say thank you for all the support on the compilation videos. And also, don't forget to go to our compilation playlist because remember, we're at number 96. So I'm sure that there's plenty of proceedings that are in these compilation videos that you have not seen. So please go and check those out. And also check out our community post where we did a poll. I want you guys to go and check out the previous 4 judges that we shared from our compilation list where we've only focused on those judges. And we wanted you to give your feedback and your poll on who did you think was the best proceeding or had the best proceeding when it came to a sovereign citizens compilation videos. Now, I know I talked enough. Let me get ready to give you the rundown of these judges. First, we will be in the courtroom of Judge Brian Oakley out of the state of Michigan. Second, we will be in the courtroom of Magistrate William Ulrich out of the state of Michigan as well. Third, we will be in the courtroom of Judge Lee out of the state of Kansas. Fourth, we will be in the courtroom of Judge Phyllis Webster, also out of the state of Kansas. And last but not least, we will be in the courtroom of Judge Akins out of the state of Washington. Listen, number 96 is a good one. I know you guys are ready. So let's go ahead and jump into this compilation.
This is not common law. It's by statute. That's not jurisdiction. That's the law that you're being charged under is not common law. It's a statute. It's an ordinance from the city of Romulus. Now, if you want to know what that ordinance says, then you can get that ordinance.
I understand what you're trying to tell me, but I'm saying the Constitution, Fifth Amendment, the Constitution have a right to express. I'm just asking questions.
And I'm answering it to the best of my ability.
This all I know is how you say it was criminal. I know criminal as common law, and I know criminal as another law.
Okay, but your knowledge is not complete. I don't know what to tell you. You don't. You're swimming in a pond. You don't even know the rules. But you've chosen to do that. And I have a right to ignore your questions if I've answered them already, which I've done more than one time. So here's where we're at. This is a pretrial. Do you want to talk to the prosecutor today? Yes or no? Yes or no? Okay, then go talk to the prosecutor. And I have a right to ignore your questions. Yes, I'm under oath, but that has nothing to do with my ability to tell you, no, I'm not answering any more questions. Go talk to the prosecutor. That's what a pretrial is for.
On prosecutors waiting list.
I don't know if you want to create a file for it. No, that's what I mean.
If you speak to the prosecutor, that knows their side of the meeting. I'm not, I just don't want nobody to be liable. That's all. Okay, let's talk to the prosecutor about that.
Calling case number 24 RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
Very well, Mr. Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, air near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by
No,
law.
I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Ulrich, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
And that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in terms of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak? Please bring the
court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code of the city of Royal Oak as it is adopted
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward. As far as the injured party, no one was injured. You guys
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case under the Motor Vehicle Code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party, no one injured. You guys are.
Officer Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district. And at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing.
Right. The next matter is State versus Isaiah Curvin, 24 TR 17. There's a name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
It's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem. Yeah.
Thank you. All right. This is your first appearance. We were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and requested hearing. So we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be. It's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, or if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence, then they're not entitled to court-appointed counsel. We'll take that up as go further. Additionally, at a trial, you would have the right to be presumed not guilty. The state would have the burden of proof of beyond a reasonable doubt. You would have the right to cross-examine the state's witnesses. You have the right to call witnesses on your own behalf and to utilize the court subpoena power to make sure they attend. Additionally, you would have the right to testify or not testify as you see fit. If you chose not to testify, that could not be used against you in determining if you're guilty or not guilty. Do you understand your rights, sir?
I do. Yes, sir.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties in a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
So on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly allegedly them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under maritime law?
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to?
I heard part of what you said. So.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me with regards of the elements of our personal jurisdiction, and also the nature cause of action until the jurisdiction, the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime law. So I can know how to defend myself, and then I can enter my plea.
Have you filed a motion for discovery in this case?
I filed in I put a special appearance in affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the special appearance. Did you receive it?
There's a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature. It says respondent beneficiary of the named defendant in constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a 1-page document.
There's only one. It's supposed to be more. I faxed to more over there. It was supposed to be like 4 pages.
It's one page.
Yeah,
Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
yeah. I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
I cannot answer a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action brought up yesterday.
Well, I've explained what you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
Because I was my special appearance didn't make it. I need to resend it as well. How can I reset it so I can have a chance to resend my special appearance because it didn't make it into. I guess you only had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before the 17th.
Hour.
That's about 1 hour. Okay.
Miss Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there maybe like the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st at 9 a.m.
Okay.
So May 1st at 9 a.m. That will be in person at the Elk County Courthouse in Howard, Kansas. You'll need to appear at that time. You'll need to have your pretrial motions filed, including your request for a jury trial. At that time, if everything's in order, we'll set a trial. Counsel, anything further?
Not on Mr. Curvin, Judge.
Mr. Curvin, anything further today?
No, Judge.
Very well. With that, we are adjourned.
All right, I'm looking for a Johnson. Do I have a Johnson?
Yes, you do. I am here. Can you hear me?
Yes, but you're not the Johnson I was looking for, but I will take your case up. have a couple. I have a Danny Johnson, and well, I thought don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
What does that
And
mean?
that means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney in fact.
You're not an attorney at law?
No.
Okay. So when you
So
say you're an
Mr.
attorney, in fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No,
right?
I'm not a citizen. I'm not a citizen.
Or-
But let me state for the record, Mr. Johnson is under doctor's care. He's in recovery. We sent the documentation over to the courts to show that, to show proof of that. We also reserve our rights to any and all reproduction or distributing of videos on social media platform. And we request the matter to be rescheduled at a later time when he can get through his recovery period.
All right, Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first appearance. He entered a not guilty plea. Actually, he objected, I think, to just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings. I believe he
I
was
object, Your Honor. I think he was
Stop.
he was
You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss Carter. I'm not Miss Carter.
Then why does your screen say Sasha Carter?
That's what it says, but I'm not Miss Carter. And it says
Who are
Stasha.
you? Who are you? Before I disconnect you from these proceedings because you don't have standing to be here. What's your name?
Well, again, Mr. Johnson is under doctor's
Do
care.
you want to tell me your name?
He's here. I've already gave you my name, ma'am. I'm his
Well, then
wife.
say it
I'm
again
Miss
because I
Johnson.
must have missed it. What's your
Miss
name?
Johnson. Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
Nicole.
Nicole Johnson. And you said you're his wife. Is that
That's correct. That's correct.
You're his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27. And on September 27th, there was an issue that he either was or was not receiving medical service. And he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago. And you say he's still under doctor's care and can't be here today, or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days
actual
ago,
surgery.
he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing at, on bed rest. And we sent in the documentation to the courts and the doctor. The doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
And we've made it clear to him that he can appear by Zoom. So I'm going to issue a bench warrant, bond
Hold
forfeiture.
Hold on one second, ma'am, because he is here. He can hear you, but
Well, then put him on here.
Oh, he's on here, but he's in a recovery bed, ma'am, and it's a violation of his rights, his HIPAA rights, to be shown and be broadcasted all across social media as far as
Bench warrant, bond forfeiture, no bond, hold.
Ms. Webster.
Oh, now do you want to be on here, sir?
Well, I'm
you
first of all,
under duress.
Are you
Under
voluntarily appearing, Mr. Johnson?
No, under duress.
I'm not
Okay,
going
I'm
to-
not duressing you at all. You don't have to be here.
Can I speak, please? I just want to let you know I'm on a series of medication that alter my I'm on a like medication that I'm supposed to be on bed rest from my procedures for the next 8 weeks and for the following 8 weeks, and then I'm supposed to start my recovery. But I have reached out to the courts. I have had the hospital reach out to the courts in reference to my procedure and my process. I have requested a continuation. I have also sent in letters to request evidence from the case to continue the case prior to these procedures that I have not got a response back. So
Certified mail.
I sent it out registered mail that the courts received, I think on the 23rd, in requesting evidence of the case to continue prior to my surgery, but having the surgeon
It's an unforeseen circumstance.
Ma'am, I want you out of the case now. You're not his lawyer. He's talking, he's representing himself. You're out.
The creator made me his wife, and
I will find you in contempt of court.
Ma'am.
Stop talking, Miss Johnson.
Okay.
Now, both of you stop for just a moment. Miss Gillette, you haven't had a chance to say anything on this. Do you wish to be heard?
Because you're acting like the attorney.
I'm acting like the court, and you owe me $50, ma'am, for contempt. And if you have another outburst, it's going to go up, and it will be enforced. $50 direct contempt by Nicole Johnson for her interruption of the proceedings. Ms. Gillette, do you wish to be heard?
Good luck with that.
Ms. Gillette?
Sorry, I was making notes, Your Honor. In this matter, there have been lots of issues with Mr. Johnson. There is a letter here. I don't know if it came directly to my office or through the court. It's through the court because it was filed in the court file of
All right,
his.
so when you say through the court, you mean it went to the clerk?
It went to the clerk and was file stamped. There
and
is
it may or may not have made its way to my office, but if it has, I haven't seen it. For the record, go ahead, please.
There is a note from September 25th, 24. His other hearing would have been the 27th. Asking he be excused. We've had lots of issues with Mr. Johnson in the past. I am taking into consideration that he has provided a doctor's note and information about that visit.
That was the last hearing. What do you have, if anything, for today from the doctor?
That was received. It was file stamped 9/27. I don't know if he's recovering or not. I can't tell you anything about that. So if he is on medication, Judge, I don't want to have anything substantive unless he's not taking pain meds. So I would move it over to November for him to be here, present, and he needs to understand that attorneys can speak for individuals, but not family members unless there's some
you won't be released in November, ma'am.
Ma'am.
$100 fine or for contempt against Miss Johnson.
Okay,
now, Mr. Carter, you may speak. Yes, sir. Now, if you're
ma'am, do you even know who you're talking to, ma'am? Because you're calling all these names. Which name? Who are you speaking to?
You told me your name was Nicole Johnson. I'm
correct. So you calling Carter, and I expressed to you that nobody's here is Carter.
Well, don't have to put Carter on your screen if you're not
Well,
Carter.
ma'am, we made the point to be here in court today, ma'am.
You
And that's under
stop
the
talking.
unforeseen circumstance. He's still
All
here.
right, I'm going to end this talk. This court is
over.
over. Bench warrant if you don't stop and get out of it. If you don't want this bench warrant, you be out of this conversation and let me communicate with the defendant.
Ma'am,
obviously,
no
Mr. Carter
defendant.
doesn't have any
He hasn't been
control over
convicted of
you.
anything.
Okay, Mr. Carter, I'm going to have to end this court because the woman won't shut up. And I'm going to have to leave a bench warrant. If you can get her to shut up and stay out of the conversation, you and I, sir, can have a hearing. Now, okay, how much time do you need this continued, Mr. Carter?
The doctor can send over the information.
I would request.
Mr. Johnson, I'm sorry, Missy, can you get that?
Hey, I'm trying to explain to you. The doctor told me it's going to be 3 to 6 months for my recovery.
3 to 6 months for your recovery.
I had a T10, T11 procedures. So it's a middle back procedure. Like I said, I haven't even started physical therapy yet.
Do you have an attorney, or would you be willing to take a court-appointed attorney?
As far as the attorney, all I would coming to do is, because I'm on medication, I don't want the court hold anything against me that I may say due to the type of medication I'm on. And two is the fact that I am requesting a continuation. I know y'all saying I've been whatever, but at the end of the day, I'm requesting a continuation at least to December, late December or January.
All right, we're going to set this over for trial. It'll be for bench trial. And what the doctor told you you'd be in recovery for how long?
I'll be 3 to 6 months for recovery.
So this is October, November, December, January. All right, January 31st will be your bench trial. Now, did I understand that someone did receive something from his doctor today or recently? Ms. Gillette, you were talking about something from a month ago.
What time?
Yes, it was filed September 27th. It said he had surgery.
Yeah, we continued that hearing based on that letter. We continued it to today. But has anybody seen anything more recently?
No.
I think the wife was reading something that said he couldn't travel, but I don't think it said anything about appearing by Zoom. I think it just said he couldn't travel or appear in that fashion. But that's what we need to make sure come January, that the doctor understands this can all be done by Zoom. And again, Mr. Johnson, would you consider appointment of an attorney to represent you?
Not at this moment, Your Honor. Like I said, I'm on medication.
Well, an attorney could sure help you navigate through this court system. I understand you wanted to represent yourself, but the attorney could sure help you.
I don't need an attorney at this moment.
All right, we'll document that for the record, Ms. Gillette, in the journal entry, that he still does not want an attorney, that we are continuing this again at the defendant's request for medical reasons to January 31st, 11 a.m. Now that's going to be for bench trial, so keep that in mind. The state will have their witnesses ready, and if you have any witnesses, you'll need to have them ready. Hopefully, you won't be under medications January 31st or in any situation that's going to affect that. But I won't issue the bench warrant. Nicole Johnson does owe me $100, or she owes the court $100. I'm going to give her 10 days to pay that. If she doesn't pay it, then she's going to face more contempt. That payment needs to be paid, Ms. Johnson, to the clerk of the district court. And that is in Eureka, Kansas at 311 North Main. And make sure you put on there contempt for case number GW 2024 TR22. And put on there that it's for payment for direct contempt of Nicole Johnson for continued. Well, you won't have to put on there other than for contempt. But I do want the rest of it put in the journal entry, Miss Gillette.
Well, if somebody tries to defend themselves, it's contempt. Exercise their rights is contempt.
Ma'am, you don't have any rights in this hearing today.
I do. I'm not a citizen, ma'am.
I don't care what you consider yourself. You do not have any right to come into any court of law and start interrupting and delaying the procedures and absolutely deliberately and intentionally disobeying what the court instructs you.
Ma'am, I called the county attorney yesterday. I called the clerk yesterday.
I am going to tell you to stop talking one more time before I
know, because you don't want me to express my rights.
This is not your hearing. This is not about you. I really hate to have to send the sheriff to whatever state you're in.
You have not given no lawful consideration to this matter,
Mr. Johnson.
The doctor's care. He has provided all the documentation to show that he's under the doctor's care, ma'am, and you have not given no consideration to that.
You are so fortunate that you're not here in person, or you'd be locked up right now.
Yeah, I am fortunate.
And he'll be locked up if he is not here in person. Mr. Johnson is ordered to appear in person for bench trial January 31st at 11 a.m. Ms. Carter?
Yeah, because you want to retaliate against him, don't you?
Ms. Carter now owes $200 in fines, and I'm disconnecting this call so I don't have to send the Greenwood County Sheriff to whatever state she's in to get her picked up and locked up for contempt. This hearing is adjourned.
Ma'am, every time somebody expresses their lawful rights to defend themselves, you hold them in contempt. Why is that? You are a judge. You are compelled to provide protection for we the people. You acting as an attorney, giving advice to people, bringing people down, and he's in a situation to where he's under doctor's orders. It's a shame that you still wanted him to present himself under the doctor's orders of bed rest and medication before the court.
Put the camera on yourself when you talk to me, Ms. Carter,
and you can
Ms. Johnson.
put it out across social media, and you can talk down on them, and you can make money off of it because you go and you spread it, and then you get up all these views.
Put the camera on yourself if you want to tell me off, Miss Johnson.
I can put the camera where I want to. That's my legal right, ma'am.
You are to appear. I will send the orders for you to appear personally because you're going to serve some time for this disrespect. Miss Johnson.
It's disrespect with what you having him do on camera.
Disconnect her. This court hearing is adjourned.
Yeah, disconnect yourself because you're unlawful.
We can come back to that one. This is Mr. Evans.
Hello.
Your Honor, this is Sylvester Evans.
Did you get the letter I mailed in, Your Honor?
I did not.
Is the court ready?
Yeah.
Okay, I mailed the
One
letter.
second, Mr. Evans. So this is Sylvester Evans. It's 380312319, 480231898, 380655525, 380820191, 480472552, and 380549215. And I don't believe you were here, Your Honor, on Monday when Mr. Evans was arraigned. But Mr. Evans at that time indicated he wanted to represent himself, and he's also indicated that to me today. I did go over the waiver of attorney on pretrial and arraignment form with him, and explained it to him and talked about it. It sounds like when I spoke with him, because he's in custody right now, I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflict, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
Okay, and I believe Judge Freund did do the jail calendar on Monday. So did you say competency was raised? I didn't quite understand that piece.
Oh no, that I was talking about the other person. Veronica Johnson was who I started to talk about.
Got it.
And then when Mr. Evans walked in, I just said, we'll get to that when we're done with Mr. Evans.
Got it. Thank you. Thank you for the clarification. All right. So Mr. Evans, So,
Yes.
we have not yet done the arraignment, right?
No, it was done
It's done, so,
Monday. And the city doesn't believe there's any change in circumstances, so would object to defendant's motion
so I
to
guess,
release or
I'm
adjust
just,
bail.
oh, thank you, Ms. Chenoweth. I guess, I just for my clarity, so this was on Monday, and we set it again for today, for what specifically?
Pre-trial and the
Oh,
tracking reviews.
okay.
Because the court set bail or bond, we set the pre-trials pretty quickly.
I
Got
would
it.
like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I can honestly say I don't recall defendant mentioning the Native American part on Monday, but he did discuss the other thing in quite more length than he actually even is today. So the court did have that before it. Now, as far as the other piece that he's presenting today, I state's position is that doesn't change anything and there's no proof.
I sent the proof in the letter that I mailed out.
Wasn't provided to the city. I haven't seen any proof. I would say that's not a change in circumstances.
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affected my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
And Ms. Chenwiller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fighting history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport. We have 4 pre-trials and 2 reviews involving those allegations, the same allegation before the court today. Has warrant fighting history in pretty much every case.
What is his date of birth? I'm trying to find him on Jabs.
My last name is Evans, it's not Williams. And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday as well.
And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you.
Can you
I'm not
please,
sure what you being a Native American chief has anything to do with you coming to court.
because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America, the Supreme Court of the United States of America. And in the letter, I've put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday. Additionally, we need to address the fact that you are requesting a waiver of right to an attorney. I will note that I don't believe that that is in your best interest. I think an attorney would be helpful to you. However, if that is what you would like to do, I want to make sure that you understand that you have 1, 2, 3, 4. And you have 4 cases that are pre-disposition, and it sounds as if you have 2 review matters, which means you've already entered into some sort of plea on those cases. But on your new cases, do you understand, Mr. Evans, that these are gross misdemeanors?
Yes, ma'am.
And you understand that with that, you could potentially serve up to 364 days in jail and or pay a fine of up to $5,000?
Yes, ma'am.
Okay, you understand that you do have a right to have an attorney, have a lawyer represent you in all stages of these proceedings. And if you cannot afford a lawyer, that you have the right to request a public defender.
Yes, Your Honor.
And that a public defender, if you qualify, will be appointed to represent you.
Yes, Your Honor.
And that you may be at a disadvantage if you proceed without a lawyer.
Yes, Your Honor. As I previously stated.
Okay, Mr. Evans, I heard everything that you had to say. I just need to make sure that you understand the rights and that you understand that you'll be required to follow all the laws of evidence and court rules which apply to this case.
Yes,
Do you
Your
understand that? And that these laws and rules can be technical and complex, and that you may not fully understand them without a lawyer.
Yes, Your Honor.
Okay, and that you realize that by proceeding as your own lawyer, if you do not represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received inadequate representation.
Yes, Your Honor.
And are you aware of the risks and disadvantages of proceeding without a lawyer?
Yes, Your Honor.
And knowing that you still choose to represent yourself, knowing the risks, you freely waive your right to be represented by an attorney.
Yes, Your Honor.
So you are waiving your right to be represented by an attorney.
Yes, Your Honor.
All right.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we
Better.
will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That could you please put on note that I asked that it be sealed immediately?
And again, Mr. Evans, those sort of things need to be done in writing to the court. Mr. Iona,
I did.
do you have any concerns about competency?
I do, but I'm hoping that if the court sets a hearing next week, I think either on Tuesday or Wednesday, perhaps that letter will have come in and it might answer.
Okay, so for right now, I did sign the waiver of attorney, but I am going to allow counsel to remain on standby. Let me see when's the next time we can. Wednesday, May 29th.
And also, Your Honor, I would like also to put on note that I mailed the letter off on a blank piece of paper and I numbered it. If it's kind of difficult to read, you might have to put something on each line because due to the circumstances, that's why I had to mail the letter off. I mailed the letter off. Because I was in a tank to where I didn't have access to anything. They have me in a restrictive tank while I'm on 23-hour lockdown. And I have no access to the law library or nothing.
All right, so we are setting these matters for May 29th at 11 a.m., all matters. If there's nothing else to address, this concludes this matter.
Just want to note for the record that the city is going to object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you have provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off and it should be on camera that I handed the letter to the guard.
All right.
The city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean, if we're setting it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
No, we are not ready to address that today. So we will
Okay.
address these matters again on Wednesday, May 29th. All right, so this concludes this matter. Bail, as I stated, will remain as previously set, as well as all previous conditions of release.
Thank you. Then we have to put the bail amounts in.
Yes, that's what I am.
Thank you.
Doing. And it's 500 each case, right, Ms. Chenweller?
Yes.
Okay, thank you.
Could I get a copy of the paperwork, please?
You will receive a copy of the paperwork. All right, this concludes this matter. Have a good day, Mr. Evans.
Same here. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.